Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kirk Damon.
And welcome back to Season 4, Episode 1 of A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers, with your host, Ben Siders, that's me, and the other guy is, as always, Kirk Damon.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders, and you can find Kirk at KirkDMN. You can follow this podcast on Twitter at LGGPod, and you can find all this information on our webpage, www. Is that too many W's? No, that's three. www.lggpodcast.com.
This is our W's anyway anymore.
Yeah. I think Scott Adams pointed out, like, WWW is an acronym that's literally 3 times as many syllables as the thing it stands for.
It's also the thing, though, but I mean, nowadays you don't type it in anymore unless you're going to type in something.
Oh, I couldn't do it last time.
You
know, I only say it because I've got it. I'm going to delete it right now. I've got it written down on my reading paragraph here. Whoops, I deleted all of it. I'm going to delete this WWW part so I stop saying it. Who uses it? Okay, so Season 4, we are going. Happy New Year, everybody. Happy New Year to you, Kirk.
Happy New Year.
Yeah.
2021 started with a bang, didn't it?
Yeah, I was almost literally. Yeah. You notice nobody ever besieges the IP offices.
Yeah. Well, I commented about the fact that I actually thought it was very interesting that we didn't receive any kind of notification from them.
I kind of kept waiting for that. I guess, but the patent office isn't really down in the capital area.
Yeah, it's in Alexandria, Virginia, you know, so it's not really in nearby or anything like that. But I did think it was interesting that they didn't say anything about, like continuing to function or anything along those lines. But I joked about it. I said, it's what my hope with it is that we have a sort of, month becoming a year thing. So, 2020 came in like a lamb and definitely went out like a lion. Mm-hmm. But then 2021 here is coming in like a lion and will therefore go out like a lamb.
So if anybody's listening to this content later and wondering what we're talking about, today is January 11th, 2021. And about 5 days ago, we had the Electoral College certification for Joe Biden's electoral victory. And that's probably all you need to know. There was a big mob at the U.S. Capitol building, a lot of chaos and mayhem. So if you're coming back to this in the future, that's what we're talking about. But things seem to have calmed down, and nobody went to the patent office. I don't think most people could find the copyright office even if they wanted to.
It's in the Library.
I don't know where it is.
I believe it's in the Library.
Yeah, I'm gonna say, the Library of Congress. But that's actually not too far from the Capitol. I haven't been to D.C. in a while to be a tourist or anything, but as I recall, the Library of Congress is not that far from the Capitol area.
Yeah, I'm trying to remember where it is. I want to say, for some reason, it's near actually the Lincoln Theater, but I may be wrong about that.
I thought it was kind of by the Supreme Court, but again, I'm going from the one time I walked around that area in 1993, so it's been a while.
And we're probably completely off base, and it's actually, in Colorado or something.
Yeah, our DC listeners are like, you guys are idiots. You don't have no idea what you're. Well, we go to DC every year. We just never go into the Capitol area. We're always out in the suburbs.
Yeah, we always at the patent office. I mean, that's the thing. And now we're out in the sort of the hotel area.
National Harbor, the Gaylord Hotel down by that area. So we didn't go this year. Maybe or last year we didn't get to go because of coronavirus. Maybe we'll be there this fall. So anyway, so today we're going to do a couple things. A lot has actually happened in terms of substantive legislation. And there's been a number of attempts at reforming or modernizing some of our IP laws that have been really going on for 3 or 4 years now and keep getting stalled out in Congress. These laws keep getting through committee. At one point, getting to the floor, and I think the Senate maybe approved the CASE Act, and then it gets held up in one of the two chambers. And the people who hold them up, you might be sitting here thinking, well, how can one rep hold up the legislation? But the answer is there's things going on behind the scenes. And Kirk and I learned a lot about this a couple of years ago in DC, actually, how these laws get passed. And I'm sure those of you who don't follow these things that closely recognize that some legislation is contentious and closely followed by the media, exhaustively debated by Congress, things like the Affordable Care Act and that sort of thing, the Trump tax cuts. But IP laws generally don't divide very well along party lines. You see a lot of IP laws that receive 80, 90, 100% support from Congress. It's just not a big rallying cry subject matter for scoring political points or talking points for election campaigns. People don't understand it. And so typically these rules are and Congress doesn't really understand it either, to be honest. So a lot of times, you have somebody in Congress who spearheads the effort from a leadership perspective, but mostly just throws the bill out to the industry and says, what needs to change? Give me your thoughts. And that's pretty much what's going on with these. Wouldn't you agree?
Yeah, I think part of it is also just there's no political capital around any of these things.
Yeah.
The last time we really had any kind of serious debate, I think, in the media around any kind of IP law was the America Invents Act. From as a patent attorney looking at it, one who was sort of deeply involved in the behind the scenes portion of that one, what you saw, 90% of what you saw in the media was wrong. What politicians were talking about with it was wrong. There was all sorts of discussion of just, what it is. But again, I think it's just you have relatively low capital. I actually want to quote, I just think this is the greatest quote talking about the fact that these things came through. This is a quote it's Christopher Bucafusco. I may have pronounced his name wrong. Law professor at Cardozo School of Law. He was quoted in an article here from Law 360, and I love his quote about this, which was once again, and this is the quote, once again, when Congress decides to do something fairly dramatic with respect to copyright policy, it does so without discussion or debate in a giant spending bill that members of Congress had basically no time to read or consider or discuss. End quote. I kind of love that quote because I think it's accurate of what you encounter a lot of times in conjunction with these big IP provisions. Is there things that may get discussed a lot in committees or things that may get bounced around in the houses, but when they get passed, they tend to get passed as part of something else.
Well, that's what happened here for sure. I mean, the Case Act has been introduced since 2017. I mean, it's come up over and over and over, and this year was the year we kind of thought it would finally pass. And I forget exactly who held it up. There are behind the scenes reasons for that have nothing to do with the actual or with the reasons given to the media and press releases. It's basically because you've got key stakeholders in the copyright industry who are holding out and have concerns. But one of the easy ways to get generally non-controversial legislation passed is to dump it into a defense spending authorization bill or other must-pass legislation like this. And really, we saw President Trump try and do that with repealing Section 230 of the Communications Decency Act, which we'll talk about that someday too, because that's a very important piece of legislation that I don't know what you think, Kirk. I have concerns about Section 230. I don't even think Trump's completely wrong about that, but I don't think you can just repeal it. It's got to be sort of replaced with something else. I think there's
a lot of problems in the fact that a lot of copyright law, and we've talked about this in the program before, a lot of copyright law tends to react to current technology.
Yeah,
and
definitely.
So by the time it's passed, it doesn't make sense anymore.
Yeah, well, because it's about copying, right? So it's going to respond to technologies that enable new kinds of copying. We'll get into that when we talk about these legislative changes.
Yeah, and I mean, you need to go no further than digital audio tape and the associated legislation.
Dead on arrival.
Audio tape. Yeah, to discuss how the fact that basically what you have this kind of legislation getting passed, these things kind of happening that don't really have, literally by the time they get the legislation passed, the technology doesn't exist anymore. And you have a huge piece of legislation, which is pointless because it has nothing to do with this.
Let's go through. There's three main things in this act. Let's go through them. One of them is the Trademark Modernization Act of 2020, which is probably the less heralded, less discussed of these two, because it's sort of the esoteric procedural changes, but they're important procedural changes, especially given the way that trademark prosecution has evolved over the last, I'd say, 18 months, 24 months. And what's interesting is that the reason the trademark system has changed so much over the last couple of years is because Amazon has changed over the last couple of years. If those of you who don't know, Amazon has a brand registry. You can go to Amazon, you register your brand, and then they will enforce preventing other people from selling products using your brand, which is really nice. The platform just keeps them off, which saves you the trouble of having to police and monitor and do a lot of that trademark work. Amazon does it for you, and there's the world's largest e-retailer, e-commerce website. Having them do that for you is great. The problem that was happening is we had unscrupulous actors who were registering brands they didn't actually own. And so Amazon solved that by saying, we're not registering a brand unless you have an actual registered trademark to that brand in the United States. Now, Kirk, you probably won't be surprised. that what happened is not that people stopped trying to fraudulently acquire brand registries. They just started trying to fraudulently acquire U.S. trademark registrations.
Yeah. And I think that's the real key thing here is Amazon did a good thing by basically saying it has to be a registered trademark.
Yeah, agreed.
Because it now says, okay, we have to have this recognized. The government basically has to go through and say, this is what it is. There's some real force behind it. Now there's some issue of, what if it's state registered trademark, stuff like that. There can be other ways to clearly protect the trademark that aren't federal registrations. But you have to put in some criteria of the fact that this has got to be something which can be relatively easily determined, and this can be. The thing that I think is that you really did bump in problematic with it was, and it's not new, you did have people trying to get both registrations and attempts at registration as a blocking position.
Yes.
And so what you've got now is because Amazon is taking these positions and saying, hey, if you have a federal registration, we can give you this additional sort of blocking position in conjunction. You don't need to enforce it in court anymore. It just becomes enforceable in the world's largest online marketplace. What you've now got is people saying, well, I want that protection, even for something that, I may not necessarily be truly entitled to trademark protection for. And so what I think you're seeing a lot of companies now go in and say, well, since I need the registration, how do I get the registration through? And in many cases, I think this is legitimate. They're looking at it and saying, Amazon has its criteria of this is what it wants in order for it to go through. Well, if I'm entitled to get that, why don't I just get it? And then I have it, even that's not necessarily what I'd want as a trademark to enforce, in litigation or anything along those lines. You may get a trademark that's less valuable in order to be able to use it in Amazon, stuff like that. But you're also seeing what essentially are potentially purely fraudulent litigations. Now, my understanding of where this came from, and they've actually just cracked down at the trademark office. We may have mentioned this on the program previously, with regards to specimens of use at the trademark office and what a specimen has to be. What they particularly cracked down on is that you have to state when web pages now were printed, or when pictures were taken from web pages. You can't just submit them generally. And you cannot submit digital mock-ups. You have to submit an actual product photo. You cannot submit a digital mock-up of a photo. And my understanding where the latter one came from was there was a trademark examiner, and I believe it was for clothes. And they caught the fact that they had received the identical specimen, but for the mark which appeared in the specimen.
You see this a lot with these cafe press type businesses where they don't, it's products on demand, right? They don't actually have the product in inventory. They just have a model with a black shirt and an image of whatever you're making. So the product doesn't actually exist, although it is being offered for sale. But what they're showing you is just, a perspective view of what the product will look like once it's made. There's nothing wrong with that. That's a legitimate manufacturing, sales, and business model. But the trademark office doesn't like that because it means that you haven't actually sold one yet. You're just giving me a picture of what the product might look like once it is sold. And the standard for getting a registration is you have to have an actual sale.
You don't have to have it physically on sale. You do have to just have it offered for sale. But I think the concern is it's very difficult for them to distinguish what's an offer for sale versus I just made a digital mock-up and sent it to you. And I think that's what they were seeing is they were seeing these guys who'd done the cafe press type thing and said, hey, look, I can make all these shirts. But I never actually have to offer them for sale. I can just make them and submit them in and say they're offered for sale because the patent office has no way to verify it. And I think that's why they pounced on the mock-ups. And again, it has created some problems in certain industries because products, on the internet now are sold via digital mock-ups. You may sell the product based upon an on-demand manufacturing, not upon an actual product. But I think most legitimate products that end up on sale, you probably have a real one. It's rare that you have zero inventory or you have nothing that's ever been made.
You think you'd at least get one, test run done to make sure it's sized right and looks okay and you can launder it and stuff like that. Why don't we do actually a 90-second overview of how the trademarking process works? Because this is an area that I don't know about you. I find most people have a sort of intuitive grasp of copyrights, or at least they think they do. They often don't really. People generally find patents bewildering and mystifying, but I think people sometimes believe they understand trademarks far better than they actually do. So at a high level, our federal trademark system is not actually where your trademark rights come from. They're all acquired at what we call common law through use. All the trademark rights are about using what we call an indicia or an indication of origin or source in connection with goods or services, right? So Kirk, you and I go out and we start a hobby store to sell, board games and RPG stuff. And we call it, Kirk and Ben's Hobby Store. Okay. Once we put the sign out and we open up for business, we've got trademark rights of some kind, probably, right?
Yeah. You attach common law rights to the fact that you're actually now using the mark in commerce associated with some goods and services. So in that case, our goods and services, and you have to specify what the goods and services are. We retail store or retail services because we're a retail store.
Games and hobbies, maybe limited to that.
Yeah, well, we have to sell our own. Yeah, we have to be limited to games and hobbies. We wouldn't necessarily get it in games and hobbies unless we sell games and hobbies branded underneath our own brand, underneath our own name. So if we made RPG stuff, for example, and sold it in our store, then we'd have a right for games.
So if we were registering, we'd register retail services in the nature of game and hobby products, something like that.
Something like that, yeah.
Yeah. So, and our substantive rights, in this case, we're in Missouri, we'd open a store in Missouri. So it would be under Missouri state law, Missouri state trademark law for what our substantive rights are. Now, for all practical purposes, nobody cares about any of that, right? Because what happens is...
People do care about it. People do care about it because of the fact that that's a common law trademark, and in many respects, that's all you get.
Yeah, and if you had to enforce it, that's what you're enforcing. But trademarks are also geographically limited. So if we open a store in Clayton, Missouri, we have rights, at least in Clayton, Missouri, maybe the broader St. Louis area, depending upon where we have actual sales activity, customers, marketing, things like that. And we can maybe creep over into Illinois a little bit, but we're probably going to be confined to St. Louis for our common law trademark rights. Yep.
One thing to keep in mind, by the way, anybody, if you ever see the superscript TM, people are used to seeing that. That's an indication of common law trademark rights or an assertion of common law trademark rights. Anybody can use that. It's one of those things where you can just simply say that I believe I have assertion of common law trademark rights. That's what that little TM means. And again, certain things are that way. The one example I always use when I give big presentations in conjunction with trademarks is if you want to see these kind of things, go grab a box of cereal. Because cereal does a really great job of having a number of registered trademarks and a number of common law trademarks at the same time on it. And you'll see a lot of TMs, a lot of times on catchphrases, maybe sort of newer logos, things like that, things that they've not bothered registering yet, but they're claiming common law trademark rights in. So again, you see that's TM, that's a common law trademark. You can infringe a common law trademark. You can be found liable for infringement. You can pay monetary damages for infringing a common law trademark. It just means it's not registered. It's not actually been a physically registered trademark. That's the only difference.
And the registration system serves a couple of purposes. One is notice. It tells the world that I have this trademark. I claim these rights, and here are the goods and services I claim them to. The federal registration system also gets you nationwide priority. So let's say we open our business today and then we file a registration. We file it today and we get the registration next year. And now we want to go over into Kansas City. And it turns out that two other Yahoos named Ben and Kirk already have a game and hobby store in Kansas City. If they opened after we filed our registration, our effective date is post-dated to when we filed it. And so we could kick them out of there and make them change their name. But Potentially. But if they were there before us, before our registration, then they've got rights, at least in their little area where they are, just like we would.
Yeah, one of the big issues you bump into is where you can enforce or even a registered trademark. When we say it gives you priority, it gives you the priority to registration. Nobody else could register the mark and get federal rights in conjunction with it.
But other people could still use it in places where you're not doing business yet.
Yeah, and that's the thing is when people can use it and where you can get infringement is a slightly different thing. And so it's important to keep in mind that sort of federal preemption for registration. If you're the first registered mark, you tend to have preemption rights to basically say nobody else can register it, which means it's very hard for them to stop you from doing business because they can't get that kind of federal registration. They can't necessarily stop you, but that doesn't necessarily mean you can stop them. And we're getting into esoteric area of trademark law. We don't necessarily need to get into right now. There's a whole bunch of sort of specific.
We could go on for hours about just this.
Yeah, well, it's one of the big things associated with it. What you hear is people referring to the Don Donut case and the Don Donut sort of area of cases, which all has to do with what this is. We're not going to get into it. There are like massive CLEs on nothing but the Don Donut case. But yeah, so that's basically what you're looking at is, when you talk about federal registration, it really says at that point in time, I've got the mark. I've got the federal rights to the mark. Nobody else is entitled to federal rights in the mark.
And the reason this matters for purposes of the Trademark Modernization Act is that it's this process of getting the federal registration that's being modified. Part of that process is that you have to submit to the government sworn statements accompanied by proof that you're actually using the trademark and that you're actually using it as a trademark and that you're actually using it as a trademark with the goods and services that you seek protection for, or at least a representative sample of them. And people have historically done this by just sort of checking some boxes and firing off some blurry scans of some box covers or taking a photo. The trademark office has historically not been overly scrutinizing about those, but due to the amount of fraud, that has begun to change. And they've begun to look at those a lot more closely. And they also have the authority, what we call sua sponte, which just means on their own initiative, to look at registrations and audit them and to cancel them if they think that your proof is not good enough or you're not actually using the marks. And the Trademark Modernization Act adds a new wrinkle here. Now third parties, and this was not previously the case, but third parties can also submit evidence to the trademark office during the examination phase to tell them why they should refuse registration on grounds that the claims of use are inaccurate or fraudulent or wrong. Basically, that the person's claiming to use it, but they're really not.
A good way to look at this, and an important thing to keep in mind when you get a federal registration for a trademark, the registry of the trademark not only is the mark, you have to add what the specific mark is, but you have to specify what goods and services the mark is used on. In a lot of foreign countries, you get things by class. There's a classification system where certain goods and services fall. It's esoteric. It was created in like the 1940s, and it's one of those things where
it's old and backwards.
But it's one of those where you still have to specify what the goods and services are. So the example would be returning to sort of, Ben's and my game and hobby store. If we were to go in and say, we want retail services, and they said, well, you have to specify the retail services you want. Let's say we said we sell board games, we sell video games, and we sell snacks. As well, because we happen to also be, have a snack bar inside the store, which is a different class from retail stores and goods. So we say we have a snack. We also sell snacks and drinks. So we have two classes for purposes of our registration. Our first one specifies a retail store service, selling these two different kinds of things. And then our second service specifies snacks. We are then required to submit what they call a statement of use, which is required to have an example of use or a specimen, which shows it in use. Commonly in like a retail store, what you would submit is you would submit like a photograph of the outdoors of the store. So you would show like, here's the sign showing the store as to what it is. Here's the sign on the door. You may be able to submit something like, here is a flyer for it. You can't submit traditional advertising for the most part. And you can't submit things like firm letterhead or business cards. But you can, like I said, so it's a photograph of the store. So let's say we send in the photograph of the store with the specimen of use. Typically, we could say, here it is. It shows all of this. Now, we may submit the exact same photograph for both classes because you can't really see what's going on inside the store in conjunction with this. That would be totally acceptable, and they may grant it. But the issue with it is that we may not actually have the snack bar. We may have filed on this, and the snack bar isn't actually there. It's not open.
We wanted to have one. We were planning to, but we're having supply issues, or we just can't afford to finish putting it together yet. There could be any number of reasons. It may be that we never intended to, and we're just lying. But more often, just business plans change between when you file, when you actually get the registration.
Yeah, no, what you're supposed to do is simply drop the second goods and services and say, hey, we didn't get this. We're not going to do it. Where the concern lies is if you look at it and say, but we're going to do it.
Yeah.
Or we sort of done
we still
it.
Intend to.
Something like that. We don't want to hold up the registration. So let's just submit it. And by the time it'll be verified, we will actually have a snack bar, or we sort of have a snack bar, hey, we sell candy bars, something like that, even though it's not really a snack bar.
There's a vending machine.
There's a vending machine. That's a good example as to what it would be. So you have these kind of filings, or when we do file it, we do have both things open. The concern that you get, with it is stuff changes. And again, what you're supposed to do at the trademark office is you're supposed to tell them when something changes. So we go in and say, hey, look, when we go into, our statement of use, we're not going to state we're using it in both classes. We're only using it in one class, drop the other one because we don't have the snack bar open, or we get it registered for both, but then we cease using the snack bar when it comes up to a renewal period. And trademarks have to be renewed every 10 years plus at 5 years. So you have to renew them at 5, 10, 20, 30, 40, 50. So it's 5, 10, and every 10 thereafter. When we hit one of those renewal periods, you're supposed to come in and say, hey, here's the new specimen. Here's the example. And we assert that we are still using it on all the goods and services in conjunction with it. In addition, the other thing you bump into is like that description of goods and services. So we said we have retail store services selling board games and video games as an example. If we now only sold board games and got rid of the video games, we'd also need to drop video games from that description. These are the things you're supposed to do in conjunction with it. The key about it is you do this when you file and when you get the mark at the beginning. You do it at 5 years, you do it at 10 years, and you do it every 10 years thereafter. Mm-hmm. So if I have the snack bar open at my 10th year and I close it the 11th year,
Technically, you should go back and drop it from the registration.
But the mark stays registered.
It stays registered in the meantime until you do that, right?
Until you do that.
And how many trademark owners do you think are really good and diligent about contacting their lawyers and saying, hey, drop this description from our trademark we haven't thought about?
Yeah. And part of it's they don't even think about the fact that, hey, they may have it, or they don't think about the fact that it's a separate class or it's a separate description. Part of it's because these descriptions are not uniform. So the example is like, we may have the statement in ours that says retail services specifically for board games and video games. Another mark may have retail store services selling games, which means that if you only sell board games, you have to drop video games from the first one, but the second one's still accurate.
Well, the reason these changes are so important also is because you'll often have, when you're prosecuting a trademark, you may get a rejection based on a prior registration where they say, well, you can't have that trademark because here's somebody else using a confusingly similar trademark on goods and services that aren't completely identical, but they're close enough. And you go look, and it's a situation like this where there's a Ben and Kirk's pizzeria down the street. And we're saying, well, they're selling pizza. They're not selling snacks. That's different. And besides, I know that place. They've been out of business, for the last 3 years, and this registration's still just sitting there. Because it hasn't been canceled yet, and it won't be canceled until their 10-year renewal comes up, and they don't file anything. And sometimes it takes the trademark office years to notice and actually abandon the case. Yeah. So it's nice to be able to start a proceeding to have that canceled early so you can get your own registration. And now third parties can even do that. If somebody else starts a proceeding, now a third party who is not part of the proceeding at all can jump in and also submit evidence that they have.
Yeah, and there was previously what Ben hinted at, what's called a cancellation proceeding, which was if the company's out of business, you can say, hey, it's canceled. I want their mark canceled. And if they don't defend that suit, it would be canceled. But those can be expensive and difficult procedures. And in some cases, it's not that they're out of business. It's that their mark covers more than what they do now. So again, you look at it and you say, hey, the pizzeria down the street also said it was a snack bar, but they don't have a snack bar anymore. They're just a pizzeria.
Or it's a bowling alley that had a snack bar, and the snack bar is gone now.
And so we want that piece removed from it. And that's kind of what this is saying now, is that you have the ability to go in and say, hey, look, we're going to challenge the use in this subclass in this particular area. And the real reason you're going to usually be doing this is because you're trying to get a registration to that particular area. And this is good because it means that what you bump into when you start doing, when you do any kind of trademark practice, you bump into issues where somebody happened to get a broader description through than somebody else did. And so suddenly you have the issue where, party A has a description which says, restaurant services, and party B has specifically, pizza parlor and snack bar. Mm-hmm. And now you can't get snack bar in light of the one who has snack bar, even though the pizza parlor was fine in light of restaurant services.
Yeah, that happens all the time.
And so you look at it, you say, hey, I want to, get that snack bar kicked out of there because really it's a pizza parlor, and those kind of things. And it allows you to sort of do this thing a little bit more piecemeal. So I think that's the real takeaway from this. What you should look at from this is esoteric. And we said, it's very specific elements in conjunction with trademark practice, but it allows you to basically boot little bits of the description out of things. Where you also bump into problems with this, and Ben hinted at it earlier, the trademark office also now has the ability to do this. They're doing what are called audits. And so basically you can have a scenario where you're only required to submit a statement of use showing the specimen in one class. So again, if you look at it, or of one of the goods and services. So again, if you looked at it and said, we have a retail store services selling board games and video games. And what we sent was a picture of, a LAN setup. That's obviously video games, but is not, the board game piece of it. But they're never going to say that's a problem. What trademark office can do is they can come back now and they can say, well, actually, we think that might be a problem because from what we've seen, you don't actually have a board game sales division. So we're going to audit you. And an audit, you're required to defend that you actually use it on all the goods and services that are underneath this, or drop them. Now, it sounds kind of like, audit is kind of this evil, like you did something wrong type of thing. I wouldn't say there's necessarily any statement of wrongness by being audited or by even losing an audit or by backing down. But, the idea is to just clean up the registrar. And we've had a few audits recently. And you can challenge them. We've challenged them in one to say, no, we actually are using it on all these things. Let us point out why, and argue with the trademark office. You could also lose them. You can also get something where the trademark office says, no, we don't think you're using it on that. You have to drop that particular, description from it. But again, I think what we're really looking at here is the ability to clean up the register and to really say when there's things that this is not really being used on, goods and services not really being used on, not only can the trademark office do it because the trademark office doesn't necessarily have the real inclination to do this, but third parties can do it where it's important to them and don't have to go through a cancellation proceeding, don't have to get a third party agreement. You can just go after it and say, hey, look, I think there's a problem because I don't think it's actually used on this component.
Let's move on to the CASE Act, which is probably the more controversial and widely misreported part of this bill. So the CASE Act is the copyright alternative in small claims enforcement. It's one of these awful congressional acronyms they like to come up with. It creates basically arbitration/mediation sort of judicial tribunal to resolve copyright infringement claims without having to go to federal court. So copyright is, in the Constitution, the federal courts have exclusive jurisdiction over it. Now, with respect to almost everything, there's a couple of small areas that still fall to the states, but for the most part, almost all of copyright has been preempted to the federal government. For all practical purposes, it's anything anybody would be fighting about these days. Normally when you go to federal court, you have to prepare a federal petition. You've got to file it. You've got to serve it. Just the process of drafting a proper petition, unless you're going to do it yourself, hiring an attorney is going to cost you a decent amount of money. I would guess most law firms who are competent in doing IP litigation, I would think high four figures, low five for a basic, simple copyright infringement case. Also online, you often don't know who the defendant is. Someone's posting something and you don't know who it is. You've got to file a John Doe lawsuit. You've got to file a motion with the judge to seek preliminary discovery. You've got to draft a subpoena and a request for records. You've got to send it to the ISP or whoever's, hosting the content. You've got to then work with them to get the information back to find the IP address. Then you got to send another subpoena to the ISP to find out who the subscriber is. I mean, just the process of figuring out who you're supposed to be suing could cost, $10,000, $20,000, $30,000. No guarantee of success. It might take you 3 to 6 months. So that's a problem for people who own content. And the CASE Act is meant to simplify things and make it easier so that you don't have to prepare the big long petition. I guess the idea is, let's be clear. IP laws are mostly commercial laws. They are intended to mediate disputes over intellectual property between commercial enterprises, business to business laws. The problem is we live in an era where the technology is affordable and readily available for consumer-based copyright infringement. And we've been struggling since this happened, 20, 25 years ago, to kind of get caught up. We used to be able to rely upon the cost of physical media or energy barriers to sort of put a natural check or limit on how much consumer infringement went on. We slapped copying levies on the media so we could recover some of the lost, revenue from infringing activities. But none of that works very well with computers and the internet. Energy barriers effectively zero, and the media is vanishingly cheap. So, the DMCA fills part of that role, and now the CASE Act is supposed to help with that too. So the way it works is if somebody thinks you're infringing their copyrights, they send you got to be served just like you would in federal court. So you still got to go through that hassle. And then once you're served, it's voluntary. So if you look at it and you say, I don't want to be a part of this arbitration thing, I want my day in court in front of a real federal judge, then you just opt out and say, no, I'm not doing it. And then you're done. And that's it. If you don't opt out, then the proceeding goes forward, but the remedies available are limited, and the amount of damages that can be collected is capped at $30,000 per matter. So, if you've got a big copyright claim, obviously this is no good for you, but if you have a big claim, you're not thinking about this anyway. If it's that big, it's worth the cost to go to federal court. This has been widely applauded by content owners, especially individual artists, independent artists, small businesses who produce copyrighted works. They've struggled for a long time to have some affordable avenue to enforce their rights and combat privacy. But there's been a pretty vocal chorus of critics, I think the EFF is among them, who think that this law is going to be weaponized by copyright trolls who are going to try to force settlements out of people for engaging in everyday internet conduct. And the common example is you post a meme or an animated GIF and whammo, $30,000. Kirk, how concerned are you about NBC trolling people over Michael Scott gifts on Twitter?
I'm not really concerned about it. And I think the thing with it is, and I think I understand where the concern comes from. But I tend to side with the people that are for this. Way I look at this, I think this is something which is going to be used by small content creators against small content creators.
I agree.
This is something where what we're looking at, large content creators, you're talking an NBC, an HBO, a Netflix, those guys are going to use federal court. They're not going to use this unless they have some scenario where it's something that's particularly small. And they bring it this way just because it's so small, they can't justify it. Whereas they previously wouldn't have brought it at all. So that's like the one place I could see, potentially being used. But they're primarily going to be worried about large scale infringements. They're not really worried about small scale infringements. The advantage I see of using this, and sort of the reason I side with the fact that I think this is a good thing, there's a lot of cases where small scale content creators get inadvertently infringed by other small scale creators. This is something where there's no, nefarious planning here. It's just people not understanding the copyright law. These are relatively low dollar things. They may be only a few $1,000s. Now there is profit on both sides of them. So it's not something like somebody's coming in and saying, hey, Whammo, you owe me $30,000 for something that was worthless to you. It's usually going to be, I think, something where it's, hey, we're both producing this same small market good. This small market good is being sold in the same commerce. We've each sold a couple $1,000s worth of these things.
Yep.
But one of us did create it. One of us is entitled to royalties from the other. And, they're upset about it. This is a way they potentially can bring this now. Whereas previously there was just no way for them to be able to afford the court. Yep. So it kind of gives that ability to sort of resolve these kind of disputes in this relatively small, again, $30,000 is virtually nothing when it comes to a copyright suit. I mean, You could readily burn through $30,000 to get a copyright suit just to court.
Yeah. That's one discovery dispute.
Yeah.
Not even.
And so it's the kind of thing where, again, if you've really got money behind this, it's not going to be used. But I can really see this being small content creator versus small content creator. When somebody just feels like they got ripped off, this is going to be a way for them to sort it out instead of what's been the problem now, where it's unless you have unless you're willing to spend $10,000 to win 5, you can't get any sort of justification that you're right or you are the content creator here. So again, that's my take of what it is. Can it be weaponized? Yes. Anything.
Of course it could, but so can a federal lawsuit. That's the part I don't understand is you still have to serve somebody, which means you still have to figure out who you need to serve. So I'm on Twitter anonymously posting my Michael Scott memes, and NBC decides they want to troll me for settlement dollars. First of all, shame on them for not realizing that shaking down people on Twitter is a terrible use of their time. but setting that aside, they got to find me first. They got to figure out who I am. I mean, I don't know. I mean, offhand, I don't know how they go about doing that, if they'd have to still go through the federal subpoena process. But they've got to find me before they got to serve me, right? I can't be pulled into this until I've been served. But once I've been served with notice of this, I mean, the effect on the weaponization is really no different than a federal lawsuit that they would file, right? It's a little cheaper for them, but finding me is still the hard part. So, it's no different than a small claims lawsuit or a collection action or anything else. You have to serve the person. Due process does not die with the Case Act. And if I ignore the lawsuit at my peril, I get sucked into this thing. But if you ignore a federal lawsuit, then they move for default judgment, you lose, and then they file the judgment with the county sheriff and they come take your car. Like it's really no different. So I think it's really overblown fear mongering. By the EFF in particular. I pick on them because I both love and despise them at the same time. About half the time I'm like, yes, thank God these guys are here, and half the time I'm like, you guys are just ridiculous. But
the one thing I put with the fear of weaponization, I do see two ways it potentially can be weaponized. One of which is, and I fear the weaponization of people thinking they can weaponize it because they don't know better.
Yeah.
And so the example being a small content creator who says, hey, I created X, which it may be a very narrow thing under the copyright law, but now saying I'm going to go after anybody who created X prime through, quadruple prime, where that really wouldn't be copyright infringement. If it goes to a finding, it wouldn't be found to be copyright infringement because of the fact that it's sufficiently different. But they look at it and say, I can bring these kind of suits. I can force the people into default judgments, win money from it underneath this Case Act, or, just get some level of damages to try to be a chilling effect. recognizing that they may not really have a copyright infringement, but under the Case Act, it may be found to be one just because of the simplification of the procedure. So I can see it from that respect that is a concern. But again, I think that's just the people who are administering the Case Act are going to need to pay attention to it. The other question, and one we were just looking up, is if there's any availability of injunction underneath the Case Act. We just can't find the answer right away. I don't know if
there's no express mention that the board has the authority to issue injunctions, but I do think they have the ability to just kind of tell. It's not like an official injunction like a judge would issue, but I think they can issue as part of the remedy, knock it off. And if you don't do that, then you've breached the ruling, and then you could go to a federal court maybe and get an injunction to enforce the ruling.
And that's where I see the potential worry is then putting that in a default type of scenario or something along those lines, then putting that in a default scenario, and then the person going and enforcing the default scenario at the federal court saying, I'm entitled to an injunction. You're in violation of the default judgment of the Case Act. Now that takes a lot of effort to do, but I could see that being one form of weaponization from this. Again, I don't see big companies doing that. They can get it much more effectively by just going and getting the default judgment at the federal court.
Exactly. Yeah, I think this is going to do the most good for small and individual content creators whose works are being taken either by competitors or by large content creators who are either cynically or just ignorantly relying on the true owner not really doing anything about it. And we've got some experience with that professionally. We've dealt with clients who've had their stuff taken by large competitors and used in an inappropriate way. We don't go file lawsuits. We just go send them a letter and say, hey, don't be a jerk. This isn't fair, and things get settled. But this may give it a little more teeth. I'm skeptical this is going to really make a big dent, but I think it will help in that band of situations. I don't think it's going to make a dent in piracy, though. Not a big one.
Yeah, I think the real value of this in many respects is going to be, and it may sound kind of strange, it's almost in the people who see this as they're not so much worried about the money. They're not so much worried about the injunction. They see it essentially as something immoral against them. And they want the reconciliation. They want the statement that, yes, this person did take something from me. It's really mine, that kind of thing with it. This can get them that, which right now there's just no good way to do it. And when you can look at it and say that's a meaningless thing, it's not.
Not to the artist.
Talking about things people created. These are artists, and so the ability to say, yes, I wrote that song, and you took it from me, even though you put it on the album and nobody bought your album because, you're a terrible singer. I still want to have the idea that says, you did take it from me and I'm entitled to that assertion by a judicial entity that it's mine. And if somebody does buy your album in the future, they have to pay me.
Yep.
And again, I think you're going to have some of that sort of coming down there is that, again, I look at it almost as being a moral type of thing. Is the real value of this. And again, dealing with this small content creator, particularly in an inadvertent infringement scenario where there is money involved, but it's not huge amounts of money. So it's just trying to bring a copyright would be pointless, but there should be a compensation across here that, now it's forced as opposed to requiring the parties to settle it on their own.
So are we worried at all about this type of thing being used to shut down fan fiction sites and stuff like that?
It may be used, but quite frankly, there's plenty of other weapons that they can already use to do that.
A DMCA takedown would cover it. And that costs way less. Yeah.
And, if somebody's really going to go after you, they're going to come after you with a cease and desist letter. They're going to come after you with a federal lawsuit. Why would they use this small claims to say this is what it is? They come after you with a federal lawsuit. They may come after you with a small claim. Quite frankly, if you get a DMCA, if you're a fan fiction and they come after you in conjunction with the small claims, this may be a place where you can literally defend yourself.
Yeah.
Because it's now affordable. And you can go after and make a fair use defense, which you wouldn't be able to. And, that would be good. Particularly, that's a good thing.
The way that we measure damages in copyright cases, they're still beholden to the rules for damages. And damages are either disgorgement of profits. So if you haven't made any money, there's no damages there. Yeah. There is, the damages, actual damages. How much money have you cost the person who owns the copyright? Again, and nebulous and difficult. What is fan fiction costing anybody? Nothing. Yep. And then statutory damages, which you've got to have a registration for. And, that's a little more nebulous because you're sort of in a range of values. But I would be shocked if like a fan fiction site got dinged with a even a couple $1,000s in statutory damages for original fan fiction set in like a universe or something like that. So there's still some practical limitations on this. And the bottom line is, before anybody comes and goes to the trouble of doing all this, you're going to get a letter that says, hey, we don't approve of this. Will you stop?
Yeah.
And if you choose not to, then they got to serve you. So there's going to be multiple opportunities for notice and avoiding this entirely.
And again, a lot of times the threat of the letter is the statutory damages, the large damage verdict. This is capped at $30,000, regardless of what the thing is. It's capped at $30,000. And I don't believe they can assert more than $30,000. So if they're going to assert statutory damages,
and it's 15 per work, so it's 30 if there's multiple works.
Yeah. So what we're looking at in conjunction with this thing is the idea of somebody coming. Yes, $15,000 is a lot of money, but if you look at it and you say, hey, you're a small fan fiction creator, you're getting forced into this. Damages are capped at $15,000, and you now have an opportunity to defend yourself in this proceeding, versus you're going to federal court. Defending yourself is more expensive. Damages are uncapped, and you're looking at $150,000 per infringement, 10 times the scale of damages. And so that's the kind of thing where I look at this and say, again, if what you're looking at is threat value, this has very little threat value compared to the threat value of something else. Again, I look at it and say, if a company out there says, I have a legitimate dispute with fan fiction, it falls underneath this case act. I don't think it's that much money, but I do think I'm entitled to be paid as to what this is. My take is you're the small content creator. This is good for you, because now you can go in front of this case act. You might be able to say, hey, it works out that you owe them this much to continue to produce your fan fiction. Mm-hmm. And everybody's happy. And that's, at that point in time, this is a good thing.
and if you can assert a fair use defense, I think that adds enough uncertainty. I mean, I'm just thinking through this. I would not want to wade into an arbitration proceeding like this and then start arguing about something that is as fact specific and unpredictable as fair use. Yeah. And potentially have a binding order from this court that could be enforced by a federal court without the ability to go back and review the facts and say they got it wrong. I mean, that's the Google v. Oracle case that's been to the Supreme Court 3 times and been reversed. Imagine if by law, once this arbitration panel says it's fair use, there is no review. Yeah. I think most people who own content don't want to run the risk of that, of having this, now none of these are not precedential. So, 2 different panels can find 2 different ways, but I think there's enough here, right? That I'm just not too concerned about the weaponization aspect. We could be wrong. I guess we'll find out over the next couple of years here. So maybe we revisit this for season 5 and see what's happened. Exactly. Okay, so the last piece we're going to talk about is there's some new language that criminalizes the operation of websites that are quote unquote primarily engaged in streaming pirated or unlicensed copyrighted works. We already have criminal copyright infringement. I have not read this provision yet. I've heard a lot of people sort of a lot of pearl clutching and hand wringing over it, and I'm not sure if that's justified or not. I just haven't had a chance to go through the language. I just think we already have criminal copyright infringement. It's mainly a hook crime. If we've got some sort of organized crime or other larger crime, then we throw in the copyright piece if we have to, so we can get federal jurisdiction and get them in front of the U.S. attorneys and in federal court. I don't know. I'm not sure what to think about this one. I generally don't like the idea of criminal IP laws. But if I guess I don't have a lot of sympathy for people who are deliberately running websites to stream pirated software. Like, well, what you're doing is wrong. So I guess I don't have a lot of sympathy for that.
Yeah, I kind of look at this and I think the general, statements, and I think what everybody agrees in conjunction with this thing is going to be, this is going to be rarely used. But it's one of those things where I don't have because there is criminal copyright infringement. I mean, I'll tell you, I have a problem with criminal copyright infringement at all. But since there is criminal copyright infringement, I'm not sure this changes much. The reason I really see this thing existing is it's a way for the Justice Department to go after the people who run a web page that's associated with criminal copyright infringement, as opposed to them trying to get at who is actually performing it, thinking of an old Napster style, type of concern here. That's really what we're looking at, is somebody who's found a way to technically dodge the criminal challenges from this. Mm-hmm. This is a way to catch them. I like your comment, Ben, is this is kind of the organized crime type of thing.
Yeah.
Hey, the mob boss doesn't know anybody was murdered. didn't encourage anybody to be murdered, didn't actually commit any murders. We need something to catch them because they're the ones who really are doing everything.
So you go to mail fraud, computer fraud, criminal streaming, blah, blah, blah.
Yeah,
I wonder if this could be paired up with RICO to do something there. I don't know enough about RICO to see how this would interact with that, if this would constitute the type of felony you could use for RICO charges, but maybe that's part of what it is. So we'll have to look into this one in a little more detail. It's interesting and kind of peculiar since we already have, streaming unlicensed or pirated copyrighted works is already copyright infringement, and there's already such a thing as criminal copyright infringement. So I'm not 100% sure why this specific type of infringement needed to be called out through separate legislation. So I kind of want to dig into the background on that because it just seems like an odd thing to single out.
My thing with it is, again, I think what it is the person who technically dodges criminal copyright infringement, but is running a website which commits criminal copyright infringement is what they're looking at here, trying to get at the owner. And again, I take an old school, original Napster type of argument, where it was the issue is did Napster actually do anything wrong because everything was being performed by its users without their knowledge. But did they really know what the system was being used for? I think that's what they're trying to target here.
They knew.
Yeah, I think, and again, I think that's what they're trying to target here is say, hey, if, you knew this, you can be subject to the same criminal infringement as to what it is. So just plain don't do that. Don't do something to be a criminal activity just because technically you can dodge it being a criminal activity. And so again, I think that's what this is really looking at. I have problems with criminal copyright infringement at all.
Yeah, me too.
But to the extent that we're looking at this, I don't think it's that big of an extension.
Okay, so there's your three main provisions. We've got the Trademark Modernization Act, the Case Act, and the criminalization of pirated copyrighted works, all in the Stimulus Act for COVID-19 relief. Naturally, this will all help us get cleared of COVID sooner. So way to go, Congress. But so there you go. This has been signed into law. It's done. So we'll keep an eye on how these things develop over the year. Maybe we'll revisit this this time in 2021. Closing out here, we'll do a couple minutes on Kirk. Kirk has finally seen Mandalorian season 2.
So I binge watched the entirety of season 2. My family ended up being at my in-laws for part of the New Year's holiday. And so I had the house to myself. So I ended up, because I've been watching Mandalorian with my kids.
We should say spoiler alert. We're going to get into some spoilers. So if you haven't seen Mandalorian season 2 yet, turn this off now because we're not going to be holding back.
Yeah, so I've been watching it with my kids. They actually really like Mandalorian, and they're in the process of watching. We are just about to start the last episode of season 1. And so I didn't, want to, it's not something I could watch when they were around. So I purposely watched it for the podcast, just binge watched all the way through it. To see what happened in season 2 so that we could discuss it. And then I'll watch it with them again. And definitely that's starting with the point, having now seen season 2, I will most definitely be watching it with them again. Mm-hmm. My take for it is going back and watching season 1, like I enjoyed watching season 1. It's reminded me how good of a show it was, but it also has pointed out just how good season 2 is. And in some sense, how much better season 2 is than season 1, which has kind of stunned me as to what it is. I'm curious what's going to happen in season 3. I think that's the sort of big opening is where is season 3 going to go? What are we going to see with season 3? They've kind of recreated the plot. I'm also, just as an IP attorney, I'm very curious where it's going to go in the marketing. And again, to sort of get with, for spoiler alert for anybody who hasn't heard it, definitely turn off now. We are essentially taking Baby Yoda out of the show, and he is by far the most important marketing aspect of the show. So what does that mean in conjunction with the marketing of the show, in conjunction with the marketing of secondary things? Or is that in some sense a red herring and we're still going to see lots, going forward? But I think we're going to see much more focus on the Mandalorian. It'll be interesting to see where it goes. And we got there with a bang.
Yeah. So for those of you, I assume if you're still listening, you've seen it.
Well, I just told you the big spoiler, so hopefully
yeah. So this is the text I got from Kirk. So I just finished Mandalorian season 2. O ellipses M ellipses G. And so we both had the same thought, like, I'm watching it. So Luke shows up, I'm watching it, and they're all cornered in the bridge of the ship. And I'm like, all right, well, how are they going to get out of this? I thought that the 2 X-Wing pilots from the Spider Egg episode were going to show up, and we'd find out that somebody sent a distress call or something like that, or they were tailing him anyway, because they kind of developed those characters a little more than I expected them to, for characters who are just going to appear and disappear. So I thought maybe they would show up and do something. And then I was not at all surprised when the radar beeped and they're like, oh, ship approaching. I'm like, oh, okay, so it's those two guys. And then it said it's one X-Wing. And I'm sure you all had the same reaction. You're like, oh no, it's one X-Wing. And I'm thinking, well, it could be Luke, or more likely it's them teasing us to think it's Luke, but then it's not. It'll be Wedge or something like that. Yeah. So the X-Wing lands, and they're making a big, dramatic, drawn-out display out of it. And I'm like, they really want me to think it's Luke. I'm not taking the bait. There's no way. And then, you know, the pilot gets out, and you see the cape and the lightsaber and the hand. And as the scenes unfold, you get more and more indisputable evidence that it's definitely Luke and not anybody else.
It couldn't be anybody else. Yeah.
So my next thought is, okay, so we've carefully cut around the face so we don't actually see him. So something's going to happen where, like, he just stands by the door. We get a over the shoulder camera angle, and they hand Baby Yoda through the door, and we never see his face. Nope. He walks right in the door, and like, oh, the hood's down. So they're nope, we're taking the hood off. Yeah. Well, then he's not going to talk. Nope. He's going to talk. It was, and at that point I was like, did they find someone to wear like a 30-year-old Mark Hamill mask? Where did they get that? It became clear that it was CGI. It was pretty well done. I mean, once I was looking for it, I could kind of see where it wasn't really CGI or where it was CGI. But overall, an expertly done scene. And it was what I think all of us as fans wanted to see from Luke in the sequels and never got, which is, you know, we saw Luke become a Jedi at the end of Return of the Jedi, but we never saw him after that at like the full height of his power and his abilities. Never saw him in sort of the elder senior role. We just saw him as the bitter old man who'd given up. And I think that was why people hated Episode 8 so much. Not so much that the movie was itself bad, setting aside the Canto Bite sequence, which I still maintain was ridiculous and stupid. But that we were teased for all of Episode 7 with the possibility of Luke in that role. And we got a couple little pieces of it, but not really. It was Luke trying to convince Rey why she shouldn't bother being a Jedi, as opposed to Luke really completing the circle and taking on the Yoda role. And we never got to see him, teach Kylo Ren or teach any of those guys. He'd already risen and fallen. And I think that's one of the reasons that the sequels just never really felt complete to us. And so this scene gave us that in one little scene, the same way that Rogue One gave us that Vader scene at the end, which was completely unnecessary to the plot, and kind of stupid in hindsight, but really satisfying to watch. Like something just in terms of eye candy and visuals, and something I've wanted to just see done. That scene with Vader at the height of his power was excellent. And then likewise, Luke, we got a parallel scene here. Luke at the height of his power, just kicking butt and taking names. Extremely satisfying. And Kirk, I think when you and I were talking about The Mandalorian, we figured they would carefully avoid any run-ins with the original cast because we just weren't sure how they do it. And it might seem a little, cheesy and just not, really fit with the narrower scope. But they handled it pretty well. I think we've got 2.5 minutes of Luke screen time, maybe. One butt kicking scene, a little bit of dialogue, and then he's gone.
Well, the thing that I had with it and the takes of it was, I had sort of similar reaction is when I heard the one X-Wing, I'm like, where are they going with this? Is this going to be the Jedi? It was when they actually showed the X-Wing, and it kind of looks old. Mm-hmm. I mean, you first see it, I was like, wait, this is Luke's X-Wing, isn't it? And, you see the cowl, he jumps out and he looks just like he does in Jabba's palace. You see the green lightsaber, you see the gloved hand hang the lightsaber, which is clearly the design of his lightsaber, on his belt or stuff like that. Where I figured it was going to go is, Mark Hamill's a well-established voice actor. I figured it was going to be, you were going to see the cowl and he was going to speak underneath it, and it would actually be Mark Hamill's voice. Mm-hmm. Because why not? I mean, he's literally a fantastic voice actor. Why not use him in that role? And, to then see the face. And my first take of it was, how on earth did they get somebody to look this much like him? Because it does look like Luke, but it's clearly aged, but at the same time, it's not perfect. It's not, exactly what you necessarily expect Luke to look like and stuff like that. And I remember I was watching the credits and going, who's it going to be? Where'd they find the actor? They're going to have to give the actor's name, even though it's Mark Hamill's voice. They're going to have to give the actor's name. And then it's like, and just Mark Hamill. And I'm like, it must have been CGI. They must have Tarkined him, as to, sort of what it was. And I was like, they did that really well. Like, it was amazing how well that was done. I thought the scene was really good. The other thing I really liked about it is you do get the butt kicking scene, and you get the butt kicking scene through a just impossible enemy. The idea that the Dark Troopers are just this unstoppable force. The Mandalorian barely stops one of them. They come back from being spaced, they're just an unstoppable force. You have, the Moff is very into, they're just going to come and wail on you. There's nothing I need to do. I'm just going to sit here because there's nothing I need to do. That kind of thing, sort of with it. And then have him just plow through them like a warm knife through butter, pardon the pun. What I also really loved is the very last one, when he reaches up and just crushes it with his hand. The idea, that Luke's got some darkish powers here. This was a force choke to a whole new extreme, as to what it is. And so I really thought they did a great job of one portrayal of Luke. I really liked the comment you made with it, is we get to see Luke be a true kick butt Jedi. It's the same as the comment I made, as I said, my favorite scene in episode 1, and the only scene I really thought was great, was the lightsaber battle pre the chamber with Darth Maul, where you see the Jedi just bouncing off of everything. It's massively acrobatic moves. These are people that are beyond the pale of sword fighters. This is fantasy sword fighting to a whole new level because of what they can do. And I really wish they would have done more with that. I mean, Darth Maul was an acrobat. Like, why did they, and a massive gymnast, why did they not use his ability to do those kind of things as an actor to that extreme? They did it. It was great. And then they killed him off. And I'm like, bring him back. He was too cool. But yeah, that was the real thing I had with it, is I thought it was a great presentation of the fact that he is just enormously powerful and what this represents. And I think that's going to be something we're going to play off of. I mean, it looks like they're setting up, we're going to have much more of the Mandalorian story. It's going to be the Mandalorian with other Mandalorians, the interplay between all these characters that we see on the bridge at the end, something with, where's the history of Mandalore? What's the future of Mandalore? Who's going to be the king of Mandalore and rule the Mandalore, king or queen of Mandalore, as to what it is, the play off the Darksaber. What does this kind of stuff mean? And then we've still got the Empire. We've obviously still got the Moff, who presumably is going to escape at some point in time and cause problems. The other thing I would say about season 2 is, as much as the ending was satisfying, a lot of the episodes in season 2 were also really good.
Yes.
I comment about it is the watery planet, I think, is my favorite Star Wars setting ever.
Yeah. It was so out of place, but it worked really well.
Yeah. And I love the planet. I love the nature of it. And to me, it just felt so Star Wars. It was the dirty, grimy future. At the same time, it had comedic elements and sort of stuff like that. But the idea of, like, this is a seaport. And, like, one of the things I really loved is, like, the fact that they have the AT-AT walker that's a crane.
Yeah.
It's just walking around in the harbor picking things out, because this happens. And it's like, okay, that's awesome. Like, this is the type of thing with it. I love the chowder dispenser. And I was commenting, I'm pretty sure they sell seafood chowder at Galaxy's Edge. I think I even had it. I know I had seafood chowder at Disney. That's why I think that may be where I had it. And they may have even dispensed it from kind of like a dispenser like that. There was, there were things in like that were kind of like neat in the way they did it. Yes, you have the little, octopus jump out and grab hold of baby Yoda's face, which is more just silly. But it was also just the general sort of, like, I think they did a great job of that being a cool Star Wars location as what a water planet should be, as opposed to Camino, which is just boring.
Yeah, agreed. Well, I got a call here in a little bit, so we're going to wrap this up now. We could go on forever about Star Wars and in other phone calls we have. So,
yes, exactly.
So going forward, we're going to try and do with season 4, I think, what we wanted to do with season 3. Now that we've got a stable technology set up that works, and we think the audio quality is good enough.
And I'm using a new microphone on this, so hopefully it sounds good.
Yeah. Kirk said the signal looks good again. So I think we're okay there. And the internet has been holding up pretty well. I have not had a whole lot of cutouts in the editing. So we're going to try and do the multi-format episodes, some shorter, some longer, basically what season 3 was supposed to be, but wound up being edamame episodes instead. We don't really have the specific plan laid out yet. We're kind of working on that, but we still want to get back to doing a more regular schedule, content every couple of weeks. We're going to try and do every 2 weeks or at least 2 a month, maybe not on the exact perfect schedule, but 2 episodes a month. So here's our first for January. We'll try and get one more out in January and sort of go from there and play it by ear. I think we all just have to be flexible until this virus is gone. So On that note, check out our website at lggpodast.com. It has links to our various platforms where you can download prior episodes. You can also get in touch with us on Twitter, Facebook, and by email. Subscribe to this podcast on the platforms and give us a review to help new listeners find us. You can find me on Twitter at Benjamin Siders, and you can find Kirk at KirkDMN. That's all for today. We'll see you next time. Lorem, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded in St. Louis, Missouri.
I worked out this morning, and I found out that there's something, Mackenzie found this online, but there's some sort of reaction you can get when you exercise intensely that basically is like an allergic reaction, and it causes me to like have a runny nose and cough. So what I've learned is I'm literally allergic to exercise. Yeah. But I'm not allergic to beer yet. So
that's good.
That tells you a lot, right? Like developed allergies to sunlight, outdoors, grass. St. Louis is slowly trying to kill me, but now I can still drink all the beer I want.